I'm not going to touch on the formalities matter and also the importance of design in the business, as it's almost similar with the EU, which has been presented yesterday by Mr. David Christian Brodele and Ms. Jessica Norma Lewis. Okay, this is the background of the MyIPO. Prior to 1983, Trademark and Patent Registration Office is under Ministry of International Trade, and then later on, an Intellectual Property Division is under Ministry of Domestic Trade and Consumer Affairs, and has been corporatized on the 3rd March 2003. This is our legislation. We are governed by we are governed on the patent, industry design, GI, trademark, copyright, and layout design of integrated circuit. Okay, I can skip this. Okay, this is our legislation and convention and guidelines. So in our office, okay, this is our Industrial Design Act 1996 and also Industrial Design Regulation 1999. We are using the 12th edition of Locarno classification, and we have a standard operating procedure for industrial design examiners, and we also use a common guideline for substantive examination of industry design, and we have a quality management of the design examination, and we also have a guideline booklets for filing a new design application. Okay, this is a definition of industry design. Industry design means features of shape, configuration, pattern, or ornament applied to an article by any industrial process or means, bearing features which in the finished article appeal to the eye and are judged by the eyes. So the keyword here is a configuration, pattern, or ornament, shape, and article appeal to the eyes and judged by the eyes. This is from the definition of article in red color. This is an article. Any article or manufacture or handicraft and includes any part of such article or handicraft if that part is made and sold separately. So in Malaysia, we also allow partial design also can be registered in Malaysia. And the word appeal to the eye from the definition under section 3. So it's appeal to the eye and judged by the eye. It means that industrial design in Malaysia, we only protect only the appearance. This registrable industry design first fulfill the interpretation of industry design. That's what it is under section 3. Must be new in Malaysia or elsewhere, not contrary to public order or morality. And the characteristic of protection, we have the shape and configuration, pattern, ornamentation, and combination of both. So this is the sample that I show that this the novelty of the design for which protection is sought lies in the shape and configuration of articles. You see this is a vase, okay, this is a vase, and you can see the ring, see the table, the dining table, and see the tire tread, okay, tire tread, this is a car, okay. All this is a tire is a functional, but you have a freedom of design. This is a on-road tire. This is a pattern ornamentation. Okay, that's the novelty of the design for which protection is sought lies in the pattern and ornamentation of the article. So this is a sample wallpaper. This is a packaging surface which also can be protected. It's not only wallpaper. Sometimes it's something, for example, a blanket, carpet. It's all the 2D. Okay, this is a combination of 3D and 2D. The novelty of design for which protection is sought lies in the shape or configuration, pattern ornamentation of the article. So this is the vase. This is the vase, shape of the vase, and this is the decorative. This is the 2D. So when the applicant they file, they have to code. Either they have to file a 3D or 2D or combination of both. Sometimes this vase is not novel, so maybe they just put the ornament here, so decorative surface. So to make very clear that their claim on it only for 2D. So their claim is important here. Okay, because sometimes let's see this vase is not novel, but when they put 2D and 3D, so you're going to reflect the novelty. Here's another example of a 3D and 2D. So you can see the shoes, handbag. It's able to for the packaging. So it's very important. Why design is very important, because of this packaging, kids will love it so much. Okay, they will love it so much. So then they will insist the parents to buy, so you can create in the market. Actually, sometimes the quality is not important. The drinks sometimes it's just normal, but just because the packaging, it can change the mind people from not to buy to buy the product. Okay, this is for example, a toothbrush. This is a toothbrush. Actually, I cut it half. It's very long here. So this not only the packaging, not only the toothbrush, the packaging also can be registered. So sometimes you see that there's so many the varieties of design here. Normally, I think previously, sometimes the small children, they would like to feel lazy to brush their teeth. So the parents, they think how to make their kids to able to brush their teeth. So they make so many designs. So with the beautiful design, so the kids they will love to buy this toothbrush. Here's a set of another set of article. This is a sample of such article. And this is in 3.1, a number of articles of the same general character on sale together or intended to be used together, and to each of the which the same design is applied. So this is the example, a set of utensil consisting of cup of coffee, see the milk pot, sugar pot. So this is a set of articles. So on the design in Malaysia, so in design Malaysia, we only protect only the appearance, not the function. For example, this is some thumb drives. Now thumb drives become very common. Somebody can get a thumb drive up to 128 gigabyte. Okay, you can get very easy in the market. There's a lot in the market, which the speed and the quality, the storage are almost the same. So people have how the newcomers will to enter the market. So they make a very nice design, beautiful design to compete. So the why design is very important, because it can attract, make decision people to buy, because the quality and function is almost the same. Same thing with contact lens. You can see now there's so many contact lens. People like to have something different, you know, just to make a different design. So this example of the for sofa bed, and also as a sofa bed and transform to bed. For design, we only protect the appearance of the sofa and design of the bed. So the process transformation is covered under patents, not under design. Okay, now what is not considered as industrial design? First, method of principle and construction. Second, features of the article are dictated solely by function. So the features of the article depend upon the appearance of another article, which form an integral part of that article. It differs only in material details or features. The features of the article do not have a clear artistic appearance. Okay, I showed you the example. Okay, this KLCC, this Twin Tower KLCC. Can it be protected under design? The question is no. Okay, yes, it's appeal to the eye, but it's built because it's not by industrial process. Okay, so the process, how the applicant like to get protection is by copyright, but not in other industry design. Okay, the protection is under copyright. Second, detectors solely by the function. Design features detectors solely by function are not registrable. Okay, characteristic lack of design freedom. However, design features incorporating functionality to a lesser degree are allowed. Okay, this is on the technical. Okay, see, this is a screw. Okay, so this is screw is solely functional, because this design to penetrate like a wooden surface. Okay, so it cannot be registered because this design is fully functional, unless, but you see that this is a small line here. This one is not in fact any functional. Sometimes the one company they want to make something different with another company, so they make something like stripe here. That we allow, but the screw itself it cannot be cannot be protected. Okay, same thing like with the aircraft wing. Okay, this is an aircraft wing. They call this an aileron. This design is called by an aileron. When the aircraft move forward, okay, so the air on the top will be the speed will be higher compared to the lower, so the pressure will be lower compared to on the bottom. So it's going to be a lifting to the aircraft. Okay, let's say somebody design, improve the design, make it look, looks like, which can improve, the lifting of the aircraft. So it cannot be protected under design because it is fully functional. Same thing with this is the fixed wing. This is fixed wing. Same thing with the aircraft blade, aircraft propeller, or vessel propeller. See the blade and propeller here, and also the helicopter blade. See all this, they call that an aerofoil design. Which can make lifting to the helicopter or aircraft. So let's say anyone, the designers, they improve the design. So it cannot be registered under design because it's fully functional. But it's different from the house ceiling fan, Like house ceiling fan, or this is functional, but it's not fully functional. If you go to the shop, any shop, electrical shop, you can find that ceiling fan, they have so many design, beautiful design. But there's an element of a freedom of design there. But for the aircraft, it's different. For a vessel, it's different. Anybody buy the propeller, not because it look nice, but because of the function. Let's say anybody improve the design, for example, like this, What this is the aircraft, this is aircraft. If you see the aircraft propeller, let's say by Boeing or Airbus or DC-10, on one aircraft with another aircraft, the engine blade, the propeller blade is different. You see, this one is different. This is Rolls-Royce engine. You see, there's a different with the bottom, and also this aircraft and this engine. But this will be different because the design of the propeller is depend to the aircraft itself. It depends to the weight of the aircraft. Which aircraft can go up to a certain altitude. So which the level, the high altitude, so that the propeller will be different. The propeller will be different because the air is a high altitude, the air is getting thinner and thinner. So sometimes going to reduce the vibration. It depends on the weight of the aircraft. So all that is functional. It cannot be registered. Sometimes, yes, it looks very nice. It looks very beautiful. But the design itself is totally for functional. It's not for the aesthetic elements. So it's a functional. It cannot be registered. I'm sorry to touch a lot about the aircraft because I was ex-pilot before. This also the aircraft. You see this where previously the wing of the aircraft is flat, and then later on they have a curve here, the curve around this area. The curve is actually not to make the aircraft look nice, but to reduce the turbulence of the aircraft. When there is a turbulence reduced, so then the drag will be reduced. When the drag will reduce, so the efficiency of the fuel will be increased. So that's the reason. So in that case, it also cannot be protected under design. But how are we going to protect protection? It's under patent or UI, or utility innovation or utility model, but not under industry design. This is in the integral part. Is must fit. There's no other features is possible in order to maintain the function of the object. Must match. Design features must not be dependent upon the appearance of another article. This is the integral part which I take from the UK. Features of the appearance of the product which must necessarily be reproduced in their exact form and dimensions so as to permit the product in which the design is incorporated or to which it is applied to be mechanically connected to or placed in, around or against another product so that either product may perform its function. So here I show you what is in integral part. Sometimes people will get confused. Integral part and spare part. These are two different things. Spare part and the integral part. Spare part and the integral part are two different things. For example, I show you like real light is a spare part. But which part is the integral part? The integral part where the part is fit and match. But you see, some of the applicants they get confused, or some of the lawyers they get confused. No, this integral part cannot be registered, but it has been registered all over the world. We receive so many applications from Japan, from Europe, from US. They apply for the real light, okay, for bumper, grill, it can be registered. But where is the part of the integral part? Which part is a fit and match? For example, this is the grill here. Okay, grill can be registered, but on this part, which are fit and match, the one cannot be registered. Okay, for this is another example. I showed you. Okay, this is integral part, which this part. Okay, but this have freedom of design can be registered. And this part, okay, this whole thing can be registered. The integral part on this part cannot be registered. Okay, because it's meant for because it's a fit and match. Okay, same thing with the start. Okay, the rim can be registered. Okay, but the integral part, let's say this is about 16 inches rim with the tires. Okay, because you don't want to fit and match, but for the rim it can be registered. So some of the manufacturers, sometimes they get confused. They thought that integral part. So I always tell them integral part and spare part, two different things. Okay, different. Another part which cannot be registered is the differs in immaterial details or features, and the design is not considered to be new if it only differs in material details. Just a simple example I show to you that a pencil. Okay, somebody file it's a sample, and somebody file another sample which is thicker and shorter. They say, oh, my one is different, so this one we not allow. And another example is pictures of the article do not have a clear artistic appearance. Let's say someone file in plain box, scan, or plain wallpaper, so it's not it cannot be registered. So this one, and another one is unregisterable design contrary to public order or morality, or that is inclusive in religion or moral standards. We will not allow that under Section 13 on the Malaysian design law. Then who can apply this, author, company, or individual? This is type of application. It's a single application. It's a normal application that we receive a lot of application. There is one design, one class, multiple application, two or more design relating to the same class or set of classes, set of articles. Okay, let's say there's let's say there's a pen, a second pen, they can file together. Okay, and associated application, same registered design applied to other articles, and same registered design which will modification applied to same other articles, but does not qualify for novelty, but they must be common proprietorship. Okay, for example, this pen, somebody for a pen, okay, and somebody for another pen will cover. So we will associated with the previous application. And the date of application, of course, we will give the earliest date. Divisional application, one or more design excluded when filing initial application. This is the form that our fees. 500 ringgit is about 100 euro. So it's very cheap in Malaysia. Okay, and in the form, in the application form, they need to give a statement of novelty, a statement relating to the representation of an article to which the design is applied that indicates those features of the representation in respect of which novelty is claimed. Obviously, this is a form. This is a sample of the form. Okay, and then they have to give the representation in the form of photograph or drawing, must be clear, and no other object that can be seen. If they file manual, so the size photo drawing have to be within the 12.56 cm to 9 times 9 cm. So this is an example of the representation file. Okay, this 2005. Okay, this is the actual photo. Okay, this application I will receive. Firstly, the applicant file on the left, and then we ask them to amend the photo. They have to improve the quality, and they resubmit again on the right. Okay, so we will accept that. This another example, design and drawing representation. So we also do a test on novelty. Okay, forget about the interface. So the examiner will have a look for the whole handphone. Okay, for this iPhone 3GS, okay, the first generation of iPhone. And we make a comparison, compare with the Motorola. Okay, so we allow that because as a whole it looks different. Okay, before we grant, we'll do the novelty search. But okay, this on the left is the motorcycle which has been registered in 2005 by Yamaha motorcycle. Okay, on the right is from Malaysian company. So you see this is the front view. Okay, there's side view. So when we do search, so it's not novel. Okay, forget about the rim. Okay, for the whole motorcycle, it's similar. So we object this application. Okay, this is filing date. The filing date on which all the following conditions are satisfied. The document mentioned in previous slide identify the applicant or applicants. So the applicant has to give a prescribed number of representation is filed. The prescribed filing fee is paid. This is a priority date. The filing date of the application, the earliest date of the early application filed by an applicant in any of the member states of the Paris Convention for the Protection of Industry Design Convention. Priority claim must be within 6 months from such earliest date. So this is, for example, this is a priority date. Okay, somebody filed in UK in 5 January 2020, and somebody filed in Malaysia. Okay, if this company in Malaysia filed, let's say in 25th January 2020. Okay, and this original owner came later on the 2nd July 2020, 5 months after B filed the application. So the last date to claim the priority in Malaysia is under 5th July 2020. So what happened? Before we grant the application, we'll do search. Of course, if without the priority document, we'll accept A. We'll accept B because he filed earlier, much earlier, 25th January 2020. Okay, and A filed later. Of course, we'll accept B and we'll object A. But when we check their priority document dated on the 5th January 2020. So what we do when we see this document, we'll object B and we'll accept A application. Okay, this is what our practice now. Okay, this first office action total dependency period in Malaysia. Normally we grant a application. It will take about 8 months. When we receive the application, we'll do a formality requirement formality. If there's no comply, so we ask the applicant to amend and submit the documents. There's no comply, the application will be abandoned. If you comply, we go to the next stage. We'll do an novelty search. Okay. Is any amendment and submission of a document within 3 months not comply, we refuse. We accept with the comply. So we issue the certificate. The period of registration is 25 years of protection. 5 plus 5 plus 5 plus 5. Okay, together will be 25 years. Okay, this labs, I think this I think I don't want to touch this. It's quite technical because we only have 30 minutes. Okay, I think I can skip this. This right of owner as a personal property and capable of assignment and transmission is something like house or car. You can hire, you can sell, you can use for your business purposes. So any article to which registered industry design has been applied. Okay, this revocation of registered in a compulsory license under section 27. At any time after registration, any person may apply to the court for revocation of registration on the ground of disclosure prior to priority date, the cancellation of registration on the ground that the registration procured by the unlawful means, the grant of compulsory license on the ground that design not applied in Malaysia. Okay, an infringement of registered design without the license or consent of the owner, a person does any of the following things: apply the design or any fraudulence or obvious imitation of it to any article, import into Malaysia for sale, for use for the purposes of any trade or business, any article to which the industry designs or any fraudulence or obvious imitation or it has been applied outside Malaysia without the license or consent of the owner. So they also cannot sell and offer the keep for sale or offers of keep for hire or any articles or product. So this infringement of IP, the risk proceedings and the remedies. Sorry, I have a sore throat actually. Okay, this infringement proceeding, section 33, is a legal proceeding against any person who has infringed or is infringing any rights conferred as perform act which make it likely any infringement will occur. The proceeding may not be instituted after 5 years from the act of infringement. So anything they have to do within the 5 years. Okay, this is remedies for an infringement in section 35. The infringement committed or being committed, damages or an account of profit and judgment to prevent further infringement or act which may be likely that infringement will occur. So the injunction to prevent further infringement. This is the internal system called iDesign system. Is used for processing the application and carry out the novelty search. In Malaysia, we have a IP online. So applicant, they can file the application use IP online. So this is a system for the internal, for the examiner to do the examination. This is MyIPO official journal. So when the application has been registered, we will publish it in the official journal. So the official journal, okay, applicant they can see, or applicant can see what it has been registered. Okay. This is our statistic. So the application, see this application, the trend of the application. So on 2019, received about 1,900 application. This is the we in Malaysia we receive more foreign application compared to local. About 70% is foreign application, 30% is local application. This is the registration. Same thing with the registration. So this is the top 5 for foreign application. So the first is from Japan, followed by US, China, Switzerland, and Sweden. This is our future direction to develop a new IT system. We're going to now we also use on the process to fully paperless. We have used a 3D format of representation views. We have intention to join one finding. We have to join the Hague Agreement or Hague system. So we need to identify the provision in national law to be amended. And also we need to upgrade the IT system for receiving and processing the international application. So this is a future new initiative. We need to we're going to review our law and regulation provision entirely to extend the scope of protection from industry design to design. Now we still use the industry design, so we're going to amend similar to European Union from industry design to design. We're also going to introduce secret design system, deferment of publication, patent design, protection period, and other related provision, including international application and invalidity procedure at the office, IP office. Currently, any let's say any practice, they have to go to court. So we're going to introduce that application that and they can invalidity procedure can do it at our stage at the IP office. So this is COVID-19 initiative. So we introduce the ease of doing business in MyIPO. So the objective is to enhance the delivery system, and second, to lessen the financial burden of the small business. Okay, first, this initiative for easy filing of the new application. So for the matter, we are doing the enhancement of advisory service. So we provide preliminary assessment of the application advise on the searching and search database, cumulative search and examination, view representation and template provided is in identifying the views, caption and numbering. Okay, this is the easy finding of a new application. When the applicant refer to our account to MyIPO. So on the ID division, so the counter they pass to our division. So we will provide the preliminary assessment of the application form. We advise on the searching and search database, formative search and examination, and we also help the applicant to do the view presentation template and define views, caption and numbering. So when the application received, so we help the applicant to file application will be correct and information and document. So when on ID division, the data entry, scan, load the forms, everything, and we do the formally examination, and then we pass to substantive examination and certificate will be granted. So this is the second initiative, and encourage and maximize digitalization. So method MyIPO electronic filing platform. We provide remote online filing, details of application submitted online, payment through electronic gateway. So this our second initiative that encourage and maximize digitalization. So on the online platform. So on the ease of doing business, we have the applicant on the data entry, scan, upload form, document and views. So everything is all there in the template. So on the design division, we do the formally examination, substantive until the certificate will be granted. So so we conclude the initiative COVID-19 and enhance the delivery system. First, if we are easy filing on the new application, pre-COVID situation need to be paid for amendment. So the applicant they have to pay article name, class, views, representation, details, novelty statement, assignment from author to applicant, filing via agent, extension of time. So with the ease of doing business, the applicant can save a lot of costs. They have to we try to avoid them to in the difficulty. Okay, we help them to avoid any mistake. Okay, so that when they receive the application, the application will be perfect. Second, encourage and maximize digitalization. Pre-COVID situation need to be on site. Okay, so the applicant will be able to file online and remote access, so they can save costs and paperless electronic system. So thank you very much.